in this part, we're going to talk about how cases make their way to the Supreme Court and what happens when they get there. There's essentially three ways that a case can get to the Supreme Court. Unlikely case is that it's the original jurisdiction. It's the place where the case starts. As I said, the Supreme Court is mostly an appellate court, meaning it hears cases that were decided by lower courts and decides whether or not those were correctly decided. But for something like a case involving an ambassador, the case would begin at the Supreme Court. You could have what's known as certification, which is a request by a lower court for the answer to a legal question, and only judges can request a review of this type. The most common request for review is what's known as a petition for a writ of certiorari. Certiorari is Latin. It literally means to be informed. What's happening here is you lost at the lower level, and you're asking the Supreme Court to hear the case by asking the lower court to send up the record regarding the case, hence to be informed. That is, you're asking the Supreme Court to find out what happened at the lower court. In order for you to be granted this petition, you must have reached the end of the line, essentially, in all other avenues where you could have appealed. So, for example, a state Supreme Court, the U.S. Court of Appeals, and the case must raise a federal question. That is a issue covered by the Constitution or some sort of national law. If you lost to the state Supreme Court and everything about your case was just about state law, the Supreme Court won't hear it. Actually, the Supreme Court rarely hears any of these cases. The Supreme Court gets about 8,000 requests for writs of certiorari every year, but they reject almost all of them. They only hear about 70 cases, right? So 70 cases are heard out of the 8,000 that are appealed to the Supreme Court. The Supreme Court doesn't explain why it decided not to hear the case and to let the lower court ruling stand. Essentially, they get the list of possible cases and they meet in conference and discuss the cases. But even there, about 3/4 of the cases they don't even consider at all. Of the cases they do consider, if 4 justices agree to hear it, then the case will be heard by the Supreme Court. That's this thing known as the Rule of 4. 4 justices need to agree to hear the case, 4 of the 9, for the Supreme Court to hear it. When the court agrees to hear the case, the clerk sets a date for oral arguments. Before we get to oral arguments, however, attorneys are going to file briefs, right? Both sides in the case are going to explain to the Supreme Court why they think their side should win, either upholding the lower court ruling or reversing the lower court ruling. And additionally, interest groups and other actors, maybe the government, will file what are known as amicus briefs. Amicus here meaning friend of the court, right? It's sort of the nice way of putting it. Really, what they're saying is, hey, Supreme Court, here's how you should decide things. And these amicus briefs can be very important. If you remember the famous case about gender discrimination, Craig v. Boren, when the Supreme Court said that we're going to have some heightened scrutiny in terms of gender discrimination, that was suggested in an amicus brief written by Ruth Bader Ginsburg, future Supreme Court Justice, but at the time an attorney for the ACLU. Okay, so that was a way in which the Supreme Court justices, they ruled based on what was written in one of these amicus briefs, one of these interest groups that is writing something to try to influence the court. As I said, the one thing we get to actually hear about how the Supreme Court works is oral arguments. They're done behind closed doors, but are recorded, audio recordings. And basically, the attorneys for both sides stand up there and try to make their case, and they're constantly interrupted with questions. Well, what do you mean by that? Wouldn't you agree that you should do it this way, and so on and so forth. People try and gauge how the justices are going to rule based on the questions that are asked, and sometimes you can tell, but sometimes it's unclear. So they read the briefs, they have the oral argument, and then they meet in conference, okay, in which they discuss the case. And this happens behind closed doors. And they start with the Chief Justice, and then they go in order of seniority, with the most most recently appointed justice, the junior justice, speaking last, and actually opening the door if somebody knocks, things like that. After discussing how they think the case should go, they tentatively vote. That is, they say, this is how we think. I'm going to ultimately vote in the case, and then they assign someone to write the opinion. Right. So again, this is this distinction. They tentatively vote on the merits, and then they write. Someone's going to write the opinion, explain why that side is going to win the case. Right. The way the opinion is assigned is that if the tentative votes, if the Chief Justice is in a majority of the tentative votes, then the Chief Justice gets to decide who writes the case. Sometimes, often for the most controversial or sort of like important cases that people are looking at, the Chief Justice will assign himself to write the opinion. If the Chief Justice is not in the majority, then the most senior justice can decide, the most senior justice who's in the majority can decide who should write the opinion. And so that person who's ever chosen drafts and sort of circulates the opinion, and then you get your actual votes. And when they vote, they decide whether or not they want to sign on to the opinion. If a majority of the court, or a plurality if there aren't, if like some justices had to recuse themselves from the case because of conflicts of interest or something, if the majority of the court is signed on by at least 5 justices, then that's precedent setting. If a majority of the justices sign on to the opinion of the court, then that's precedent setting, meaning lower courts are supposed to be bound by the ruling. The way the justices interpreted the law, the reasons why they said one side won, lower courts are supposed to follow those, the logic that's laid out in that opinion. Okay. Alternatively, if there's fewer than 5 signatures, maybe 5 justices all agree which side should win, but they can't be 5 justices agreeing why that side should win. Well, that's the judgment of the court. That means that side won, but it's not a precedent-setting decision. Now, you could have also at the same time what's known as a concurring opinion. All right, concurring opinion is when one of the justices who was on the majority side decides, well, I want to say something too. And they can come in 2 forms. A regular concurrence is essentially, I agree with who should have won, and I agree why they should have won, and maybe I want to highlight some things in the majority opinion. A special concurrence is when you write an opinion and you say, I agree that this person should have won, but I don't agree about why they should have won, right? And so I'm going to write a separate thing saying, here's some other logic for why they should have won. If you're in the minority, that is, if you vote for as a justice that you think a side should win and that side doesn't win, you might choose to write a dissenting opinion. What a dissenting opinion is essentially a ruling about why the majority was wrong. Excuse me, it's not a ruling. It's a document explaining why you think the majority was wrong. And sometimes you might write this because you want to highlight some things to interest groups and attorneys about future cases. Okay, we lost this time, and here's why we lost potentially. Or here's the argument that the justices bought, and this is the one you have to fight against, and this is some holes in that argument that you can try and sort of pick at and see if in a future case you can change the justice's mind.